And now it's time for another case law update. Our next case law update covers the WorldVue Connect Global LLC versus Szuch case in the Fifth Circuit originating out of Texas. This case involved a dispute over the breach of a non-solicitation and a non-compete provision in a contract. Here's what happened. WorldVue provides customer support services ranging from entertainment systems to Wi-Fi for hotels and their customers worldwide. Jason Szuch is the owner of international and domestic hospitality support businesses. Szuch owned Hospitality Wi-Fi, which he sold to WorldVue Connect in 2022. As part of the agreement, Szuch received a minority interest in a new company, WorldVue Global. Part of this transaction included the transfer of a highly trained customer support team and the transfer of Hospitality Wi-Fi's confidential information. Fast forward to 2024, and the business relationship between WorldVue and Szuch broke down, resulting in a settlement agreement in which WorldVue agreed to purchase Szuch's interest in WorldVue Global, and Szuch agreed not to compete with WorldVue or solicit members of WorldVue's workforce for 1 year. Specifically, the non-compete provision stated that Szuch and his related groups and businesses, the Szuch parties, would not solicit or recruit employees or independent contractors of WorldVue in a restricted area that included the United States and Canada. As a remedy, both WorldVue and the Szuch parties agreed that the non-compete and non-solicitation provisions could be enforced by an injunction. Additionally, the disclosure of confidential information would entitle a party to injunctive relief. On the same day the settlement agreement was signed, members of the Szuch party sent emails and messages around a work chat discussing WorldVue employees in the restricted area that the group wanted to recruit. 2 weeks after the settlement agreement was signed, the Szuch parties recruited 4 employees who provided services in the restricted area. A month after the settlement agreement was signed, WorldVue sued the Szuch parties for breach of contract, seeking a preliminary injunction to stop the Szuch parties from recruiting WorldVue employees. The district court in Texas granted WorldVue's request for a preliminary injunction. The Szuch parties appealed. On appeal, the Szuch parties argued that the district court committed 3 errors. 1. The district court wrongfully interpreted the settlement agreement to include solicitation of employees who live and work outside of the restricted area. 2. The district court erred in considering WorldVue's workers to be employees or independent contractors, as they were employed by a third-party agency. And 3. The district court incorrectly concluded the Szuch parties used confidential information to recruit the workers from WorldVue. In response to the first argument, that the district court had wrongly interpreted the non-solicitation clause to include employees who live and work outside the restricted area, the Fifth Circuit upheld the district court's injunction. Under Texas law, contracts are interpreted by their plain language. The court determined the plain language of the non-solicitation clause included employees whose jobs were supporting networks in the restricted area. While employees themselves might live and work outside of America and Canada, they still provided support in these 2 countries. The employees were within the plain language meaning of the non-solicitation provision. In response to the second argument, where the Szuch parties argued that the WorldVue employees were not employees or independent contractors, but rather employees of a third party, the appellate court agreed with the district court's ruling. The court wrote a short comment stating, agents can be both employees of third-party agencies and independent contractors of WorldVue. The Szuch parties breached the contract by attempting to recruit WorldVue's independent contractors, so the district court was correct in issuing a preliminary injunction. In response to the third argument, that the district court incorrectly concluded that the Szuch parties used confidential information to recruit workers from WorldVue, the appellate court agreed with the Szuch parties. The Szuch parties argued that information about workers' identities, compensation, and skill level is not confidential. Instead, it was general knowledge that Szuch obtained before working with WorldVue, as Szuch himself went to dinner and traveled with these employees. He obtained personal knowledge about these employees rather than confidential information. WorldVue argued that because it had purchased Szuch's knowledge, it now owned that knowledge, and so Szuch could no longer use it. The court held that Szuch's personal knowledge about the employees, which he obtained before WorldVue purchased his company, was not confidential information, as defined in the contract. However, the information about compensation, skills, and value after the 2022 transaction is considered confidential, so Szuch is enjoined from using post-2022 information. Under Texas law, to obtain injunctive relief, the party must show irreparable irreparable injury. It has long been held that injury resulting from the breach of a non-compete covenant is irreparable injury. WorldVue properly showed evidence of irreparable injury to their business as the Szuch parties breached the non-solicitation and non-compete provisions of the settlement agreement. Overall, the Fifth Circuit upheld WorldVue's request for injunctive relief against the Szuch parties poaching their employees, with a slight modification to the definition of confidential information, excluding Szuch's personal knowledge of personnel. So why should you care? This is a classic example of a good deal gone bad. When that happens, it's so important to look closely at what each party knew and had access to track what was done inside and outside of your systems, and distinguish between what is and is not confidential information. That's it for this case law update. I'd like to thank Frances Warden, a law clerk in our Denver office, for her help with this update. I hope you found this episode informative. Thanks for listening.